Yes. Clear, yes.
I'm the new law. I'm the manual over there. I'm the taxman manual. No, I'm the taxman manual.
Leadership Council seeks permission on behalf of prosecution to address issue number 1 and issue number 2. Before, if your leadership is well versed with the facts, if your leadership is not well versed with the facts, so should I brief out the facts?
Yes, I want to.
Okay, sure. Much obliged. And before that, I would like to clarify that issue number 1 and issue number 2 will be addressed by me, and issue number 3 and issue number 4 will be addressed by my co-counsel. So, your leadership, I request you to give permission to approach the facts. Much obliged. So, I would like to run through fact sheet. I would like to give a brief about the facts. So, the timeline. Yes. You measure this one, and the red one is for the victims. So, your leadership timeline of the event starts from 2nd July 2006, when Ada Sharma is born. Then the The case starts from 30th June or 2024 evening. Ada, a 17-year-old student at SPVH College, borrows a scooter to meet her friends for a birthday trip. While riding past an old restricted area, she notices a flickering lights and hears low voices. Despite hearing rumors of mysterious activities, I'll point out this rumors on mysterious activities, she decides to investigate. Ada sees a group of dark robed figures led by women in a red sari entering a locked building. She records the scene on her phone. But the video captures only darkness and the faint humming sound before the loud disturbance. The last time Ada is seen alive, 30th June 2024. 1st July 2024, Ada fails to show up for her birthday trip. She reported missing by her friends on 1st July. 3rd of July, after 3 days of searching, investigators access Ada's cloud data and track her wiretag location. Her body is found in remote section of the campus. Near restricted building she entered. Her body is inside a box wrapped with red sari with signs of struggles, bruises, bite marks, missing fingernails and shaved head. Investigator initially dismissed the marking as random but later suspects geometric patterns which do not meet any of the ritualistic background or any of the religious symbols. Bite marks on Ada's body match Raghav Iyer's denture profile. Semen traces found, no match. So 5 accused were identified with the help of footage recorded by Ada. So these are the facts. If your ladyship is satisfied with the facts, may I please proceed to issue number 1. Much obliged.
Just one query I had.
Yes.
You said that the missing report was lodged by Ada's friends.
By the warden and missing report was reported. 5 accused were recognized, and when we establish this section, another theory comes up, that is last seen theory, criminal law.
Counsel, can you tell me how was this footage extracted?
So it was extracted from Ada's phone.
Can you tell me what procedure did the prosecution adopt to extract this footage?
So what happened is when the body was found, her belongings were found, we recovered the phone, and as section 63 says, whether printed, stored, recorded or copied, and the phone was belonging to Ada and it was recorded from that and stored under her phone. So that was the main reason why we can reliable on this evidence.
Was there any Panchanama conducted at the time of seizure of this instrument?
Okay, so this Panchanama issue is addressed by my co-counsel, so he will be covering this in the cross link before the chief anyway. Is that fine? Okay, much obliged. And your ladyship, I would like to come up with this thing. After establishing this evidence, we get a new theory, which is last seen theory, which says if a person was last seen with the deceased before their death, it raises a strong presumption of their involvement in crime. However, this theory is a corroborating evidence, so we will complete the chain of circumstances will be completed, but it is corroborating with section 63 evidence. And now, last seen theory, and I would like to also.
Does the last seen theory include last seen on the footage, or last seen theory only means when somebody is physically seen the accused and the victim together?
So I would like to refer few cases where last seen theory is where it is recognized for the direct evidence, but as section 63 says, the admissibility of, I would like to repeat that line.
You get my question?
Yeah, I can totally understand that. I'm getting, but I
So
would
you are
like to
drawing this last seen theory from the footage,
from the footage, yes.
not from the eyewitnesses' statement, right?
No, not from the eyewitnesses statement, but it is corroborating with watchman statements, and so watchman was the last person who saw Ada, and he also saw SUV.
He saw SUV.
Yes, he also saw an SUV. And CCTV footage is also with us.
He says he has seen a scooter.
Yeah, but there is another preposition also given with the charge sheet with to the witnesses by the, so which mentions he saw the SUV. if you want, you can ask. Yeah.
Can you point out where is?
Yeah. So I would like to request the organizers to provide that preposition aspect, which
Yeah.
would be from the prosecution. Can you please provide? Middle quote. These are the statements provided to witness.
This is the statement of
Watchman, Ayu, and the forensic experts. Which also shows that Allah was following a black group of individuals. And for that,
Just 1 minute now.
yes,
You point out where is it about the STP?
I would request Watchman, can you please provide your understanding?
No, I have been given the statement. You must be having the statement, right?
Yeah, so that statement which was provided to Watchman, we had the statement and we did give that statement to the witnesses. It was provided during the chief by the organizer. He stated there was or SUV
Five
spotted.
students were later arrested after being faintly identified in the footage retrieved from so-and-so, who were also victims' friends. Additionally, all 5 were spotted together in a white SUV
Yes.
near the restricted area around 11 a.m. On what date but on 11 a.m.? Bearing the plate number so-and-so and having been spotted to hang around the open garden near the crime site.
A day before. 30th of
Alright, we'll come to the statement whether it's
Yes.
corroborated or not.
And I would like to provide you few lasting theory cases which are emphasizing on date of occurrence. I have highlighted the points. So if the court will permits, you can please pass.
Is it not in your memorial?
Yeah. It is like we have a reference cases mentioned, but this is another reference case to that. Can you please court clerks, can you please pass it? Thank you. Another case, which is State of Maharashtra versus Damu, son of Gopinath Shinde, on 2000.
Can you tell me what is the ratio in these two judgments which you have just provided?
Ratio.
What is the ratio of the two judgments on which you are wanting to
Okay,
rely on?
so yes, so I another case which is Navneet Krishnan versus State of Inspector Police, where I underlined the date of occurrence is. I just want to mention, I just want to clarify that. I just want to point this out that lasting theory is considered, and the date of occurrence I marked down. In all of the cases, date of occurrence plays very important role. And we want this to be replicated to our case, and the date of occurrence should be considered as 30th of June because that is the main, that is the initial time when the crime started, and date of occurrence is very important in lasting theory cases.
So tell me what is the ratio of these judgments that you have just given? Navneet Krishnan, can you point out the ratio?
Okay, so you want us to clarify the ratio of how does this case replicate to our case?
No.
How we want the judgment to be
What is the
replicated?
ratio designated of this judgment? What is the ratio laid down by the court or by the judges?
Okay, so the ratio, as in Navneet's case, it was mentioned, it was stated by the court, by the judge, that lasting theory is very important, but it should corroborate with chain of evidence and with the other corroborating evidences where mens rea and actus rea should be also proven. And the judgment, one of the judgment where the accused were convicted, and other judgments are where the court has stated the importance of lasting evidence and the date of occurrence. And the date of occurrence is considered as the base of the case.
Okay, what is your contention? What is the date of occurrence here?
So in our case, we are considering date of occurrence as 30th of June when CCTV footage was detected, when Ada's footage which she had recorded was detected, when watchman saw her last time. That's the main, when Ada went missing, that's the main date which we want to consider for to continue our legal proceedings further.
Counsel, you have not recorded statement
statement
of the person who has actually extracted the data from Ada's mobile. How have you provided a copy of that footage to the defense and the court?
So, footage of where from the accused were recognized.
Yes.
So it would be submitted to the court.
Has the footage been provided by the prosecution to the defense?
To the defense, so it is not provided to defense, but it is been provided to the court. And if your ladyship permits, we will definitely provide the footage to the defense. And charge sheet is still ongoing. The charge sheet provided, it is not the final charge sheet, and we are still the charge sheet is still ongoing.
Okay, and have you recorded the statement of the expert who has extracted the footage?
So it is not been recorded because it directly belongs as the section 63 says, it directly comes from the source phone, and it is extracted from the source phone. So that we have not yet done from, like we have not yet taken the expert advice.
So have copies of the footage been prepared or
Copies of the footage is being prepared. Okay, so footage has not been prepared, but we have submitted this to the court.
So then why have you given 65P certificate for what?
So we are just referring the section where electronic evidences are also considered crucial, and electronic evidences are also considered to be same document as the normal document will be. And just to correlate everything, and we also want to mention in the sections that after proving last seen theory, the burden shifted to defense side, that the burden of proof shifted to the respondent defendant side, that where were the accused at the time of crime scene. So this.
So why did you prove your case? Otherwise the burden doesn't shift on them.
Yeah, so when we prove last seen theory, it definitely would shift to them. And just to also mention everything, each and every case law, I would like to also read out another case law, Protection of Child from Sexual Offences Act 2012, where penetrative sexual assault, section 3 and 4. This involves any form.
Counsel,
Yes.
tell me what are you addressing the court on now?
Okay, so why I am addressing that, why the date of 30th June should be considered, just to mention that I am reading out the POXCO section because 30th June was the time when Ada was minor, and just after for 2nd July she turns adult. So just to consider the seriousness, the heinousness of the crime, we should consider the date when the crime was occurred.
So now have you moved to issue 2? You are addressing the court on issue 2.
This is the issue 1 itself. If your ladyship permits, I can move to issue.
Issue 1 is commission of the date of commission of crime.
Yeah, but it also follows that what should be the considered, what should be considered, the date of crime or the legal, or we should consider when she got missing for legal proceedings. So we are considering the date when she got missing because it would enable POXCO Act as well, because she was a minor at that time, where penetrative sexual assault, section 3 and 4, it involves penetration into a child's body. Is a serious offense. It includes penetration of penis, finger, or any object in vagina, anus, mouth of child. Making a child penetrate another person, that also includes that. Non-penetrative sexual assault, section 7 and 8. It refers to touching private parts, making a child offender, making child touch offender's private parts, or any sexual activity involving physical contact without penetration. So even if the semen are not raised to, are not related to DNAs of the 5 accused, still they would be considered as bite marks are also found. And I would like to refer the case of if Irfan Afroz, son of Shanullah Farooqi versus the state of Maharashtra, where court has stated that court clerks, I would request you to please pass on the judgment. In this cases, another case is Pramod Lakshmikant Upadhyay.
What is this on?
Yeah, so
Irfan?
so the bite marks were found, and court has stated that bite marks should be, if the bite marks are found, it should be considered as corroborating evidence, and the authenticity of bite marks, there should be an odontology report which must be provided, and our forensic expert has already provided the denture profile which matches to the accused of Raghav Ayers. So it is good.
Sorry, but now you are going on the facts of the matter. You said you want to address me as to what should be the date of commission of crime. For that you referred POCSO.
For that I referred POCSO, and that for that
But from POCSO what you have referred is you are only getting into the facts, bite marks and...
so we are referring that she was minor at the time when the date of commission, when the crime was committed, because forensic expert report says that she was found dead when on the date of late 1st July to the early of 2nd July, and before she was deceased, there was a prolonged sexual and physical assault, sexual and mental assault on...
Point out the concerned section from POCSO which talks about the age of the victim.
Age of the victim. So in POCSO, anyone below 18 years of age is considered as minor, and the sections we are trying to put in this is section 3 and section 3 and 4.
Section 3 and 4 are the
Penetrative
punishment
section.
sections.
Yes.
Where is the age of the victim mentioned? Which section says that any victim?
So your addition section 2 will be appropriate, which says...
Section 2, which subsection?
So I am not very versed with the subsection right now, and I would like to say that it concludes. I can say what it concludes. That it concludes that any child, any children, any person who your lordship counsel seeks permission for another additional minutes.
I give you 30 seconds.
30 seconds for issue number 2.
Your entire issue number 2 is left.
Yes.
And your time is up.
Yes.
I'll give you 2 minutes.
For issue number 2.
Yeah.
Thanks for the leadership. Much obliged. So I would like to read out the section for Juvenile Act, Justice Act. Section 2, Clause 35 of Juvenile Justice Act defines a juvenile, a child below 18 years.
Can you tell me what is your issue number 2?
Issue number 2 states that whether Farhan Mirza should be tried as an adult or under Juvenile Act.
Okay.
And any person who, this was after the Nirbhaya case, there was an amendment done in 2015. Any person who is between the age of 16 to 18 years has committed a heinous offense must be tried as. So this is section 2, clause number 35, which defines the age of juvenile.
Yeah, please proceed.
Yeah, and after this, there was an amendment made in 2015, which stated that if the crime is heinous and the child is between the age of 16 to 18 years, so he must be tried as an adult irrespective of date of appearance. So we are pleading judge, we are pleading this court, we are pleading leadership to be that the accused must be tried under the POCSO Act. That's our main, and the heinousness of crime will be proved by issue number 3, where there is
tried under POCSO Act or under the regular law and non-juvenile justice.
non-juvenile. She should not be tried under juvenile justice because fabricating of evidence is also done. Section 228 of Bharatiya Nyaya Sanhita criminalizes the act of fabricating false evidence. The purpose of this section is to prevent misleading legal proceedings, which will be proved when we will with the chief of witnesses, which will be proved that how the evidence was fabricated, and the accused background should also relate to that.
So you are saying that the accused should be tried under the regular law, not the juvenile.
Yeah,
because he has fabricated evidence.
No, because it shows the mental capacity of the accused, that how capable he was to understand the consequences of this act. And it also section 110, conspiracy, criminal conspiracy, where if 2 or more people plan a serious crime like rape,
BNS.
yes, of BNS. Your lordship, if your ladyship, if you may permit with 1 minute.
Just complete this.
Okay, section 39 also, for abatement of offence, anyone who helps, encourages or instigates someone to commit rape or murder can be punished as if they have committed the crime themselves, even if yeah. So if your ladyship is satisfied with the judgment, I will also pass the judgment for Juvenile Act. So these are the 2 judgments. And if your ladyship is
Are
satisfied,
these judgments after the amendment?
yes, after the amendment, where so court has stated the mental capability should be treated as foremost thing, and
Can you tell me which para?
so I've underlined the issue.
So this, you're trying to say this judgment says that even if the child is is between 16 and 18, he can still be tried under the regular law, not the juvenile.
Yes, and the mental capability should be the foremost thing which should be considered. And by conspiracy abetment, by conspiracy and abetment act, and by the fabricating of evidence, but it is showing that the mental capability, the mentality and accuracy are both were included in this, which will be proven in justified manner when we do the chiefing of the witnesses. So, if your ladyship is satisfied with my arguments, may I please pass the
Yes, please.
podium to my co-counsel. Much obliged.
Your Honor, the counsel seeks permission. Your Honor, first of all, I would just like to give a clarification. The section mentioned under BNS was 61, criminal conspiracy, BNS 2020. Other than that, I would also like to, without wasting further time, I would just like to mention a report of
Can you find out in the meanwhile what section is, which section of juvenile justice, sorry, POCSO, says that the victim has to be below 18 years?
Section 2 states it. The subsection
Subsection?
is still will be I would just like to submit one of the NCR report. Your Honor, the total cases for investigation in our nation with respect to rape are 44,785 on page number 16, Your Honor. Out of which 26,508 goes to the charge sheeting. The charge sheeting rate is 77.9.
Counsel, I don't want to know the statistics. You proceed with your issue.
Okay.
Yeah?
Unfortunately, Your Honor, the conviction rate is that low because we do have certain loopholes in our law which are used. To overcome those loopholes, the introduction of amendment came in year 2015 under Juvenile Justice Board Act, which clearly stated that preliminary assessment should be conducted if a child commits a crime when he is between the age of 16 to 18. Now, coming to the heinousity of the crime, coming to the brutality that the crime was conducted, I would just like to state that in Satish versus State of UP, it was clearly mentioned that whenever a rape and murder of minor age less than the prescribed age is conducted, it should be considered as the rarest of rare case, and the accused when convicted should be punished accordingly, and it should be considered as a rarest of rare case.
Does this judgment say that even if the accused is between the age of 16 and 18, he should still be tried under so counsel, your co-counsel did not point out the relevant para from the judgment actually, which says that even if the accused is above the age of 16 or below the age of 18, he can still be tried under the.
So, may I please highlight the points again?
Please, I am giving you the judgments. Highlight and give me
Yes.
the meaning.
Your Honor, actually this contention came after the Nirvaya case, which is also known as Mukesh and other versus State of NCT Delhi and others, whereby the court observed that this is actually the loophole whereby the brutal crime or the brutal crime which requires a cold-blooded intention, which requires a premeditated intention, and the person is aware of the fact that what crime he is going to conduct and what will be the consequences for that crime. The pleasure and pain, the pleasure with respect to the punishment that they'll get, what will be the proportion or ratio or proportion with respect to that, all those consequences were considered. And hence, they suggested that there should be an amendment in the Juvenile Justice Board Act, so such criminals should not left in the society since they are the threat to the society. Your Honor, this I am proving not only the rarest of rare case, I am also proving the fact that it should be considered that when a person is between 16 to 18, but if he commits a crime which is that heinous, which is of that gravity, that the conscience of the society is shaken, in that case, it should be considered that the person should be treated as an adult in a regular court manner. Moving ahead, Your Lordship, I would also like to mention that as already suggested by my co-counsel, the day Ada went missing, that should be considered the day of occurrence of crime, because the day she went missing, after that she was murdered at late 1 to early 2, according to the forensic report, which will also prove during the during the proceedings of this court. But the point here is, Your Honor, that when before she was murdered, she was tortured. She was prolonged tortured. She was sexually assaulted. The bruises, the bite marks on her body clearly provides the fact. Not only that, the forensic report which states the fact that vagina was totally ruptured, which proves the fact that she was being subjected to a sexual assault, which is even not which is not justifiable at any point. So,
Assume that her vagina was ruptured for the very first time in this incident and not earlier.
Your Honor, that's the forensic report that is stating she was just 17 years old and she was not indulged in any kind of sexual activities.
Give me all the witness statements and the forensic. Yeah. But their statements are much like the watchers. Sorry, we just give them an extra time that we are discussing.
Your Ladyship, as I said earlier, the Protection of Child from Sexual Offences, POCSO Act 2012, defines the child under Section 2D, suppose D, that as any person below the age of 18 years. Moving ahead, Your Honor, proceed with my.
Yeah.
Your Honor, I would also like you to please focus on the fact that under Section 63 of rape, what is rape? A man is committed rape if he penetrates his penis to any extent into the vagina, out urethra, or anus of a woman, or makes her to do so. Inserts to any extent any object or part of the body. Manipulates any part of the body of a woman to do so. Applies his mouth to vagina, anus, urethra, or makes her to do so with him or any other person. Your Lordship, this clearly states the fact that mere presence of semen will not amount that the rape has been committed. The fact that she was constantly penetrated, there was a constant penetration, forced penetration. There was a constant sexual assault that was conducted on her body with respect to the marks and all. which proves the fact that she was subjected to rape. Lordship, Your Ladyship, I would also like to refer the fact that when we talk of the rape when it was committed, she was also subjected to torture, which proves the fact that when she was subjected to torture, the rape was committed. So first she went missing. The first instance of the crime, she went missing. The next instant, she was tortured and she was raped. The after incident was that she was murdered by strangulation. This proves the fact that this case consists of various chains of crime, and hence it should be considered as stated in Machhi Singh and versus State of Punjab, which clearly stated that rarest of rare case, the test to determine the rarest of rare case indicates the guidelines. The guidelines are that the application to cold-blooded, calculated, gruesome, and multiple incidents, whereby in this case there were multiple murders. Here she was murdered at each and every moment when she was raped, Your Honor.
Okay, what about what is the investigating agency saying with respect to the semen which has been found at the spot is not matching with any of the 5 accused who are arrested, which goes to show that there was some more accused who are present at the spot. So what is the status of investigation with respect to that?
Your Honor, that's the reason this charge sheet is still open. The other 3 accused are still on search. We are still searching that who all were involved, because according to the CCTV footage, there were total 8 people who were followed by other. The thing is that if they were following, the 8 people were there, so those 8 people were in, there is a possibility that they are involved. But since our honorable court our honorable court needs evidence and not possibilities, that's the reason why the investigation is still open and charge sheet is still open.
So counsel, how do you think will the 5 accused who are in custody face a fair trial in absence of probably the main accused?
Your Lordship, that's what our contention is. The bite marks prove the fact that Raghav Iyer was involved. Now this fact, if it is
What
proved,
about the 4 other accused?
I'm just
Assuming these 5 accused were present at the spot, I assume that what you are telling me is the truth. And let's go by saying that all 5 accused were present. But there is definitely one accused who was also there and who is still not being taken in custody by the investigating agency, whose semen has been found at the spot. So how do you think will these 5 accused get a fair trial in absence of one more accused? Don't you think they all should be tried together?
Your Honor, under section 35, arrest 35 of BNSS, Bharatiya Nagarik Suraksha Sanhita, it clearly states that police may arrest without warrant. In that case, the arrest.
I am not on the point that why are they arrested. I am on the point that in absence of the main accused, how are these 5 accused going to get a fair trial?
Your Honor, there is a clear criminal conspiracy that happened between all the
And
accused.
one of the conspirators is missing.
Your Honor, that's the reason. Since one of the conspirators is missing, we are admitting their fact. But we may not allow the others to get misplaced. That's the reason why we brought them in front of this honorable court. The other reason was that there was.
I'm not saying that we should let go free. They can be in custody, or if they want, they can take bail. The trial can begin after the 6th conspirator is taken in custody. The charges can be framed against all of them once all the accused are taken in custody.
Your Honor, these 5 accused, especially Farhan Mirza, the day when the crime was committed, he was a minor. So, considering that fact, if we'll not bring him in front of this court, there are possible chances that he will be tried as a minor under Juvenile Justice Code. That's the reason why.
But your co-counsel just put an argument that it should not be tried as per Juvenile Justice.
That's the reason why we brought him in this honorable court, so that we may prove the fact that he is not a juvenile and he should not be tried as a juvenile, and that police custody should be provided. And other than that, whatever decision the court may take with respect to the framing of charges should be taken into consideration. Moving ahead, Your Honor, I would also like to say that fabrication of the evidences also may take place. The tampering of evidences, the hostiling of witness also takes place, because of which all the steps were taken by the IO with respect to the arrest. Moving ahead, Your Honor, I would like to state the fact that when we talk of last scene theory, a chain of incidents should be covered. So the chain of incidents starts from the 30th June. Ada was seen by the watchman going towards the restricted area. After that, they saw that she was seen going towards the restricted area. The next evidence comes to apply the chain is whereby the CCTV footage records that she is recording 8 people who are following him with black.
Which CCTV footage of?
CCTV footage of college.
All right.
Yes, with respect to that restricted area. So towards that restricted area, the third evidence comes into the picture is the recording taken by the Ada's phone.
So, sorry, counsel, to take you back. Has the CCTV footage been extracted?
Yes.
The investigating agency has seized the CCTV footage from the college DVR?
Yes,
It is.
it is already been submitted in the proposition
All right.
as well as in the report. It has been submitted. Charge sheet.
Okay, have you recorded a statement of the witness who has extracted the footage from the DVR of the college?
That will be that was recorded by the IO, so that will be proved by the chief during the IO.
All right.
Also, Your Honor, the fact that the CCTV footage was considered to be the electronic evidence under section 63 of BSA. It is very much important and essential to consider the footage of the CCTV recording. Moving ahead, Your Honor, I would also like to state the fact the next chain of incident is that since she was last seen with the accused, she went missing and then directly her body was found in the same restricted area where she was found to go along with those accused. This proves the fact that the accused were present on the day on the day itself, and this also proves the fact that the Ada was murdered or raped by the accused itself. Also, Your Honor, I would like to state a procedural fact, which states that under section 330 of BNSS, which imposes an embargo, that a forensic report being a section 330 of BNSS imposes an embargo.
Wait, I'll just go on the section.
Yes.
Section
330.
Yes, counsel.
Section 330 of BNSS imposes an embargo that a forensic report being a document must be challenged by the accused within 30 days soon after the supply of each document with a proviso that the court may. Your Honor, there was no such application made on behalf of the defense counsel nor by the accused challenging the forensic report. This clearly proves the fact, Your Honor, that the report was not challenged only on the basis that they were aware of the fact that they will get caught.
Where is the question of challenge at this stage? We're just opening your prosecution case.
Your Honor, it should be done when it is submitted within 30 days.
Submitted where? Can you tell me as per which provision you're telling me this?
Section 330 of BNSS imposes an embargo that a forensic report being a document must be challenged by the accused within 30 days soon after the supply of such document with a proviso that the court may.
Section 330 of BNSS is no formal proof of certain documents.
Ma'am, please.
You are reading this from a judgment.
Yes.
Section 330 30 talks about no formal proof of certain documents which are not mistaken.
If your lordship may permit, should I read the sections?
Yes,
No formal proof of certain documents,
correct.
where any document is filed before any court by the prosecution or the accused. The particulars of every such document shall be included in a list, and the prosecution or the accused or the advocate for the prosecution or the accused, if any, shall be called upon to admit or deny the genuineness of each such document soon after supply of such documents, in no case later than 30 days after such supply.
So can you tell me when were these documents filed in the court?
Your ladyship, these documents were filed before the addressing of the court itself. The evidences were provided before the.
They have 30 days now to admit.
Okay, your lordship, it's already on the discretion of the bench. I am just referring to the fact that whether it will be challenged or not, because it requires an application. We have not yet received any application with respect to the challenging of.
So you have just given me that the court's documents have just been given to the court right now. They will peruse it and they will decide whether to admit or to challenge.
Your Honor, the documents were submitted prior to the proceedings of the court.
Yeah, but 30 days are not over, right?
Your Honor, that the facts are silent.
All right. I'll read.
Your Honor, moving ahead, I would also like to bring to your notice that when we talk of POCSO Enactment Act, the POCSO is something, not something, I'm sorry, the act of POCSO. The intention behind POCSO is that it is for the prevention of sexual offences against the child. When we talk of the prevention of sexual offences against the child, it means that they should not be punished after doing the sexual assault. Instead, they should be prevented from doing such sexual assault. The reason behind that is that there will be a presumption of crime has been committed by the accused themselves. It comes under the section 3 and 4, which has been also stated by various Supreme Court judgments, which clearly states the fact that preponderance of probability is considered in criminal justice in just 3 cases: number 1 POCSO, number 2 rape, and number 3 NDPS Act. In all these 3 cases, the only exception to the criminal justice system whereby the preponderance of probability is considered if the chain of the circumstantial evidence is established by the prosecution, and hence the burden of proof shifts on the defense side to prove their client not guilty. Otherwise, the court may presume that the accused are guilty of the offence that have been committed by on the mind. Also, Your Honor, I would like to state a fact that Ada, she was an aspiring student. She was an enthusiastic student. She was a courageous female, but she was killed brutally because the accused were on the fear that if she survives, she will tell the world that who have committed the crime. That's the reason she was murdered. That's the reason her voice was stopped from being heard to this court. That's the reason we are standing on behalf of Ada and being the voice of the Ada. We would request this honorable court to ensure that justice is imparted and no accused should be left without punishing. That's all.
You address this court on issue number 3.
Issue number 3 and 4 both.
What was your 4th issue?
Fourth issue, that whether POCSO should be considered or not. I oblige you.
Whether POCSO should be considered or not
As in the date, it is with
whether
respect. Victim should be considered as a minor. Oblige you.
I would like to highlight a point. The case.
Is a sequence of events. So when she went missing should be the start of the offense. So it is submitted that the victim actually went missing should be considered the date of offense as it marks the last verifiable moment as she was seen alive before encountering harm. In the present case, Ada Sharma was last seen on 30th June 2024 around 7 pm when she left her hostel on the scooter. The fact that she did not return attempts to contact her failed indicate that she became the victim of an offense that night itself. Ma'am, in the case we refer.
Defense, right?
Yes. So the ma'am, so your ladyship, we referred the case A.K. Verma versus State of Delhi, which states that the Supreme Court noted that when a person is reported missing, the subsequent evidence indicates foul play. The date of disappearance can serve as a critical reference point for determining the offence was committed. The forensic report, your ladyship, the forensic report does not provide the precise time of death. It says the night of 1st July to the early morning of 2nd July. The exact time of death is not given in the forensic report. It makes it necessary to rely on the last seen theory, which mandates that the last known sighting of the victim is treated as a crime's occurrence date. The last seen theory, your ladyship, plays a crucial role in establishing the timeline of an offence. In present case, the victim was seen last alive on 30th June 2024 around 7 pm when she left to off-campus meeting trek with her friends. The video evidence capturing her moving towards the northern area section of the campus, after which she was never seen again. Given that she did not return, the presumption arises that the crime took place immediately after her disappearance. So, ma'am, in another case,
So are you trying to make a proposition?
yes,
That 30th June should be construed
Yes,
to
Your
be the
Lady.
date of commission of offence, and therefore your client should be tried under POCSO.
no, your ladyship. We are stating that the date of occurrence of the
Because
crime
date
should
of
be
occurrence
30.
If it is 30th, then the
Then
crime-
our client Farhan Mirza will be considered minor. Like he is a minor.
So you are representing all 5 accused or only Farhan?
So we are representing all the 5 accused. Farhan Mirza was minor at the time of offence. We first of all, defense, your ladyship, denies all the allegations. We deny all the allegations on us. Prosecution has failed to provide the chain of evidence clearly, which shows the guilt of our accused, and that's why we deny all the allegations. So, by relying on the
You are
date,
trying to impress upon this court that date of commission of offence should be construed as 30th June.
yes,
So in that case, you are also admitting the fact that the victim was a minor on that day, and therefore your clients, the accused, will have to be tried under the provisions of POCSO and not
Ma'am.
DLS.
and regarding that, my co-counsel will deal with the issue of the POCSO.
All right.
Yeah. So I'll continue with my
Alright.
submission. So applying this principle in the 11th case that commission of crime to be 30th June. The defense contends that Ada Sharma was last seen alive on 30th June 2024. She was officially reported missing on that day. The prosecution has presented the absence of definitive forensic findings regarding the time of death further strengthens the necessity to treating that 30th June should be the date when she went missing, and that should be considered as a date of commission of. In conclusion, the defense respectfully submits that the only legally tenable date of offence is 30th June, and that day should be considered for the commencement of the legal proceedings.
Do you have any supporting judgment to show as to what should be construed as the date of commission of offence?
We don't have any copies of judgment with us right now, but
No problem, proceed.
and the last scene theory, we have judgments relating the last scene theory, which also states that the last victim was last seen should be considered as the date of offence, because we after that we cannot assume what happened with the victim. So she went missing. That day should be considered, your ladyship, because that day is a crucial. After that, when and the precise time of death is not given in the forensic finding. It is given. But precise.
Report says that
Yeah, night of 1st July to early 2nd July. But
Correct.
offence start from the offence start itself when she went missing. That is the time when the offence, the start of an offence begins.
How do you say so, counsel? She may have gone missing past midnight. And then,
Your ladyship, the date is given. The watchman last seen her at 7 p.m. leaving the hostel. And
correct,
then,
but a time of death is estimated to be either the night of 1st July or early 2nd July.
but the
So can we presume it was after 12 o'clock?
no, your ladyship, we state that the time when she went missing, from that time the start of the offence
What time
began
did she go missing?
after 7 p.m.
So do you have anything to show what happened from 7 p.m. to 12 p.m. in the
The
night?
CCTV footage, this ma'am, the CCTV footage states that she went to the northern section after 7 p.m.
Can
So
you
precise
tell me
time is not precise.
What are the timings in the CCTV footage?
That is, ma'am, prosecution has failed to determine the timing when she went missing.
All right.
Yeah. So we consider this date as commission of. Should I start? Your ladyship, should I start with the issue number 2?
Yeah.
That's organization. So your ladyship, issue number 2 states that whether Farhan Mirza was minor at the time of alleged offence but attained majority at the time of arrest should be tried in a Juvenile Justice Act, or whether the severity and nature of crime warranted that under provisions of regular system. So, your ladyship, before beginning with the arguments of this issue, I the counsel, want to state that the defense strongly deny all the allegations and assert that they are accused are innocent. The prosecution's case rests on weak circumstantial evidence, unreliable forensic analysis, and speculative interpretations, failing to establish any credible link between the defense accused and the heinous crime which has been happened.
My last scene theory is there. No?
And
So how I think that they have failed to establish any link?
then last scene theory they have mentioned, but that doesn't give us the whole, like we can presume that she went missing and the offense happened. The link between victim and the accused is not clearly seen. During in their arguments, the victim and the accused was also there with her at the time she went missing. Is not given, and nowhere it is shown that the accused were also with her at that time. Man, this is weak link, and we cannot presume that on the basis of treated with the heinous, with the allegations of heinous crime. So, Your Ladyship, just to satisfy the query of this issue, I would like to start the arguments of this issue. So, Your Ladyship, we submit that Farhan Mirza should be tried under Juvenile Justice Act, and he was a minor at the time of alleged offence, and the Act's provisions protect rehabilitation over retribution. The primary issue here was a Farhan Mirza, a 17-year-old at the time of an alleged offence, can be tried under adult criminal justice system or the juvenile justice system act. Section 1(4) of the JJ Act explicitly states the provisions of the act shall apply to all the cases involving children below 18 years of age, irrespective of their attained majority at the time of trial. So, the very important case judgment. Farhan Mirza turned major on 2nd July. On 2nd July. Yeah, yes, correct. So the most important case regarding the context of juvenile justice is Umesh Chandra versus State of Rajasthan, which particularly concerned with the determination of age of juveniles under the relevant legal frameworks. So here, the Supreme Court ruled that the relevant date for determining whether an accused is a juvenile at the date on which the offence was committed should be considered on the date on which the offence was committed rather than the date the accused produced before the court. The decision emphasized juveniles should be protected from adult penal consequences due to their age at the time of their actions. The court decision reinforced the notion that juveniles should not face adult criminal penalties. In this case, remains the cornerstone in discussions of the juvenile justice in India. Also, Your Ladyship, Section 213 of the Act also states the child in conflict with the law. 213 of the JJ Act, Juvenile Justice Act, also states the child in conflict with the law, which means the child who is alleged or found to have been committed offence and who has not completed 18 years of age at the date of commission of an offence. Ma'am, the case, the judgment, Your Ladyship, the judgment we will cite is this principle was reiterated in the judgment Pratap Singh versus State of Jharkhand. When the Supreme Court emphasized that the date of offence is crucial for determining whether the individual qualifies as a juvenile. The court further clarified that JJ Act should apply the cases where the accused had not turned 18 at the time. Also, Your Ladyship, the one contention we are producing here, the defense, it is given in the file. The prosecution has also the facts of this particular case also say that the Farhan Mirza's artistic interest is also wrongfully implicated here. So we have arguments for Farhan Mirza's artistic interest is wrongfully implicating him in the crime. It is totally wrong. His fundamental right given in Article 19(1) of the Constitution provides his artistic expression and linking his and also where the facts which are linking his creative mind, artistic expression to the criminal intent is violative of his fundamental rights. There is no direct evidence which proves the involvement of his artistic view, and it cannot be considered for accusing him and charging him with the grave offences such as rape.
So basically, you're contending that Farhan Mirza should be tried under the Juvenile
Yes,
Justice
yes,
Act
Your Ladyship.
and other accused should be tried under POCSO.
Ma'am, we are denying all the allegations. Also, are no accused of us. No one has committed the crime. We are denying all the allegations.
No, but once you say that the offence has been, you want the court to construe that the date of offence should be 30th June.
Yes, Your Ladyship.
So by virtue of you yourself arguing that the date of offence should be construed to be 30th June, you are yourself admitting the fact that the accused was, the victim was a minor on the date of commission of offence. The moment you admit the fact that the victim was a minor on the date of commission of offence, you are inviting POCSO provisions.
Again, so provisions will be dealing with.
No problem, but you, this is, I'm just informing you what your argument,
Yes, validation.
repercussions of your argument.
Yeah, defense knows that determining the date as 30th June. Yeah.
Alright, get it.
Yes. Also your leadership. Section 15 of the JJ Act, the Section 15 of the Juvenile Justice Act also states transferring a child to the regular criminal proceedings. The Juvenile Justice Board must conduct a preliminary assessment of his mental and physical capacity to commit a crime. In the present case, no such assessment has been conducted. And making an attempt to prosecute him into a regular criminal law is legally unsound because the prosecution have not submitted any assessment report regarding the IQ of the Farhan Mirza. This has we have also stated the precedent regarding this. In the case of Ajit Guzar versus State of Madhya Pradesh, it is a notable case that addresses treatment of juveniles in context of serious offences. The case primarily revolves around the application of Juvenile Justice Act and the procedures for determining whether the juvenile should be tried as an adult. The Madhya Pradesh High Court in this case ruled that whether a juvenile is charged with heinous offence, it is essential to the Juvenile Justice Board to conduct a thorough inquiry to determine juvenile's mental and physical capacity to commit a crime. The court emphasized that assessment must be carried out before any decision made regarding trying juvenile as an adult. Section 19(1) of the Juvenile Justice Act also mandates that the Children's Court must hold an inquiry to ascertain whether a child should be tried as an adult. In case of Farhan Mirza,
Can you provide a copy of this judgment?
your relationship, we are very sorry that we don't have any companion right now with us.
And then just at least have a look at it. If you're done reading. Actually, you don't have the judgment copy at all.
Actually, the compendium was not complete, so we are not relying on any compendium.
Which one? I'm on page 16.
Then ma'am, your relationship page 70.
Okay. Which judgment? Gujral versus? This is of which year? 2020.
2020.
Alright.
Your leadership,
So this, as per your submission,
let's say 30 seconds.
you can do it and deliver it. You do issue the cover though.
Yes. And marriage.
Your Ladyship, the Council seeks permission to proceed with the arguments. Much obliged, Your Ladyship. Your Ladyship, the Council duly due apologies for the inconvenience caused due to my bad throat. Your Ladyship. I will be dealing with issue number 3 and issue 4 in this case. The defense stands before you today in the firm belief that justice must be guided not by conjecture, speculation, or mere assumptions, but by the highest standard of fairness, due process, and the rule of law. The 5 accused before the Honorable Court, Raghav Iyer, Aisha Deshmukh, Farhan Mirza, Nisha Verma, and Kunal Tiwari, have been wrongfully charged and subjected to an investigation riddled with inconsistencies, unsupported forensic findings, and speculative inferences. It is our solemn duty to ensure that the Honorable Court is presented with the truth, untainted by prejudice and firmly rooted in law. The prosecution's case is deeply flawed. It rests on circumstantial evidence, unreliable forensic interpretations, and conjunctural connections that fail to establish the guilt beyond a reasonable doubt. The DNA evidences excluded all the 5 accused from the most serious charges, directly contradicting the prosecution's theory of exclusive involvement. While
How do you say so?
the semen traces found at the crime scene do not match any of the 5 accused. Also, there is no physical evidence found that directly links all the 5 accused to the crime scene or to the victim that clearly states that the victims were not present at the crime scene, and there is a possibility of other
Victim or accused?
sorry,
Yeah.
accused were not present at the crime scene, and the
But the footage from the phone clearly shows that they
recovered through a cloud data and not through her phone. It itself, and the prosecution did not point out that. And also, the CCTV footage on which the prosecution is relying does not show any clear facing. The faces are obscured. Only Ada is been showed following several figures. That too, no precise number of persons going to the restricted area is mentioned in the fact sheet, which again itself points that the prosecution has failed its duty to duly investigate, and no proper investigation, no proper evidences are being proved to the Honorable Court, and all the 5 accused have been falsely charged.
CCTV footage shows that a group of individuals dressed in dark clothing
Yes,
proceeded
yes, Your Honor.
towards the northern area.
Yes, Your Lordship.
Right. And then there is a SUV which was spotted, and all these 5 people were sitting in that vehicle in the same area.
Your Ladyship, Ada was
So can you throw some light on this?
yes, sure, Your Ladyship. Ada was seen going out of the campus around 7 p.m. on the night of 30th, which the watchman in his statement stated. Then, through the CCTV, she was seen on the same night going towards the restricted area, following a group of individuals which are yet to be identified. And the 5 accused were spotted near SUV at the morning in around 11 a.m.
But at this, in the same restricted area.
in the same restricted area, but in the morning there is a delay of 7 hours in the crime scene, and that does not, the restricted area, not only the accused, it is a campus, it was a campus. Many other students as well were spotted in the same area, and
Is that spotted in the CCTV footage that some other students are also seen going towards the restricted area?
no, Your Ladyship, that again, the prosecution has failed to investigate thoroughly on the CCTV footage, and also the evidences were not produced before the court, nor the copy was submitted to us, and therefore we contend that the prosecution has failed in its bound duties.
Oh, but the fact that you're not asking for a copy of the footage shows that you have no objection to the footage.
No, Ladyship, this is the first trial, and we hereby deny all the allegations put on all the 5 accused, stating that this case based on just mere assumptions, and that cannot be the sole reason to convict 5 accused. There is no substantial or there is no prominent evidence that directly links all the 5 accused to the crime, and states that all the 5 accused together have conspired to this heinous act, and therefore we plead that none of the accused is involved in this heinous act, and we state that there is some other perpetrators who the prosecution has not yet identified, and just to shift the burden of their proof on the defense, and just to get rid of their duties which they are bound to, that to investigate beyond reasonable doubt, just to shift the duty of investigation and get rid of them, the prosecution has failed in its duty. May I continue with my arguments? Much obliged. The issue number 3 states that whether the circumstances and evidences in the present case fulfill the judicially established criteria for classifying it as rarest of rare, thereby justifying the imposition of maximum penalty permissible under the law. Your Ladyship, the defense submits that the prosecution's narrative surrounding the tragic death of Ada Sharma is fundamentally flawed and demonstrably fails to meet the exceptionally high burden of proof required to classify this case falling within the narrow confines of the rarest of rare doctrine, as meticulously established by the Honorable Supreme Court in Bachchan Singh versus State of Punjab. The very cornerstone of this defense rests upon the demonstrable ambiguity inherent in prosecution's forensic evidence, specifically the unsettling revelations and explicitly presented in the official autopsy report presented by Dr. Kavita Menon, the designated forensic doctor, states that the semen traces recovered from the body and clothing of deceased Ada Sharma unequivocally do not match traces found in the victim's body and clothing. DNA analysis revealed that semen did not match any of the 5 arrested individuals, indicating the involvement of an unidentified person.
Correct. Counsel, this only indicates involvement of unidentified person.
Yes, Your
It does
Ladyship.
not indicate that these 5 persons are not present at the spot.
That is the job of the prosecution which they have failed, and without proper investigation, without any concrete evidence submitted to the court, they have just charged falsely allegations on our 5 accused.
Counsel, you have done enough research. You must have also come across many judgments which say that usually there are no eyewitnesses to offences like rape or offences of 490 where cruelty is meted to the wife by the in-laws because it happens within the 4 corners of the house.
Yes, Your Ladyship.
So then therefore what the court is required to do is go by the circumstantial evidence, the last seen theory and the technical evidence which has been provided.
Yes, Your
So how do you
Ladyship.
deal with this last seen
Yes.
theory? How do you deal with the forensic report and the footage?
Your Ladyship, there at the crime scene itself, there was no recovery or no material was recovered as evidence that could directly link the accused to the crime. Only bite marks of Raghav Iyer was matched, and that too I will be dealing it in my next issue. No weapons, tools, or forensic evidence that directly link.
Whether the mobile of the victim was recovered from the spot?
No, Your Ladyship. Mere suspicion or allegations without material evidence do not suffice to establish guilt.
Counsel, on behalf of the prosecution, you will have to answer this query at the time of rebuttal that the phone has not been recovered from the spot as per your own charge sheet.
Your
Yes.
if you may allow.
Yeah, not now, later. You get that time to work on the answer.
Your Ladyship, the prosecution's reliance on purely circumstantial evidence as detailed within the forensic report lacks a strong foundation. Moreover, while the attempt to use the bite mark from Raghav Iyer as primary evidence, there is insufficient proof that he was involved in the rape, torture or killing of Ada Sharma. According to the National Academy of Science, it states that bite mark is subjective and lacks scientific validity and have contributed wrongful conviction in the past.
Can you tell me how is this identification done of the bite mark? And how do you identify these bite marks out of the body? What test is conducted?
That we will be countering the forensic expert who has done the autopsy report.
Alright.
Much obliged.
How will the autopsy expert tell you about the bite marks? He has not done the matching of the bite marks.
The forensic expert has
I got clarification about it. Sorry, postmortem is done by the forensic expert.
Yeah. But he has not done the matching of the bite marks, right?
No, I'm the forensic expert for the most population, so that the questions may be asked to them.
Your Lordship, the bite marks is done in the autopsy report and it is attached with the autopsy report.
uh, Your Ladyship, if you may want to for
No,
the
I got it.
that's okay. Another piece of report states the identification of 5 individuals including Raghav Iyer, Aisha Deshmukh, Farhan Mirza, Nisha Verma and Kunal Tiwari relied on Ada's footage. However, in the same report it says the footage is of poor quality. The footage that Ada captured on her phone, it is of poor quality and it shows nothing but darkness. And that you can see in the in the mood proposition itself, and also the CCTV. From the CCTV, it is also seen that only several figures shrouded in dark robes moving towards one of the old unused buildings are seen, led by a woman in red sari. Here, the defense wants to bring light upon that there might be other superstitious or occult practices and a group might be involved in this crime and they could be the actual perpetrators, which the prosecution has failed to examine, and the uninvestigated ritualistic elements found at the crime scene also states a clear possibility of other perpetrators involved, and the 5 accused are not related to this crime and have been falsely charged. That
The fact that ashes, a small doll, lemon chili charm was found at the spot and the accused were also last seen at the spot. How do you deal with this situation and how do you say that these accused are not at all connected with what has been found at the spot?
Your Ladyship, the prosecution has failed to provide a link or to provide or to show that the accused were the actual perpetrators or were the actual people who were involved in the occult practices. There is no evidence as to state whether the accused were involved, and the accused were found.
Circumstantial evidence, how do you say there was no evidence?
The accused are not seen clearly anywhere. They are just seen near SUV in a car, but it is a gap of 7 hours. Ada was seen at the night at 7 p.m. on 30th, and the accused was seen next morning 11 a.m. And this 7 hours of gap clearly states that the accused were not present at the crime scene when the actual crime initiated. Therefore, the defense respectfully submits that the present case does not satisfy the rarest of rare doctrine as established in Bachchan Singh vs. State of Punjab and further clarified in Makshi Singh vs. State of Punjab. The Honorable Supreme Court has consistently held that capital punishment should only be imposed where the crime exhibits extreme brutality, shocks the collective conscience of the society, and where the possibility of reform is wholly ruled out. However, in this case, the prosecution's reliance on speculative interpretations and an overextension of legal principles failed to conclusively establish the accused's guilt. Therefore, we pray that this case should not fall within the rarest of rare doctrine. Uh, Your Ladyship, I would like to move with the fourth issue that the prosecution has raised about uh, whether victim should be considered as a minor according to POCSO. I will. Your Ladyship, the defense firmly submits that all the 5 accused are not involved in this crime and have been falsely charged. The um, the basic criteria for POCSO, that is lack of evidence on the part of prosecution. The prosecution has failed in establishing prima facie case against accused. Even with presumption of guilt, there is no evidence that states that a prima facie case is against all the 5 accused. That itself lacks in the core foundation of this law. I just request 2 minutes to briefly sum up.
30 seconds.
Okay, much obliged, Your Lordship. Second, inconsistencies in the evidence. And third, the prosecution has failed to prove beyond reasonable doubt and the absence of mens rea. Here, in POCSO cases, it should be proved that the accused who have committed the crime had the mens rea to commit the crime. The prosecution has failed to even prove that, and therefore we pray that all the 5 accused are wrongfully charged. Much obliged, Your Lordship.
Your Ladyship, if you like, we are asking for permission for rebuttals, or should we go for the chief first and then rebuttal?
After the chief.
After the chief.
I mean, that's.
Yes, ma'am, after the chief, the rebuttals.
Yeah.
Much obliged.
After
That's
chief,
how it should be,
yes, ma'am,
no?
chief closing statement, rebuttals.
Right.
Use the mic. Tell to witnesses in case if you want to use the mic, you can use the mic.
Ladyship, with your permission, may I please proceed with the chief?
Yes.
So first, I would like to call I for chief question. You take oath that whatever you will be stating in this court today would be truth, and you bind yourself to that.
Yes.
Okay. Please introduce yourself.
Myself, Rajna Kumar, I am the police inspector of the police station and I am the investigating officer of this particular case.
Okay. And how did you find Ada's body?
We used the cloud data retrieved from her phone through Mario that was traced.
Counsel, you are not supposed to ask a leading question in chief.
So how it was? Like, please explain and briefing that. Okay. As for your answer. And can you please also explain what did you see when Ada's body was found?
When we went through the old administrative building, the room was locked from outside.
Point of the network room was locked from outside, old administrative building of the campus.
And then we found her body placed in a wooden box wrapped in a red saree and there were superstitious elements surrounding the box.
Oh, okay, that's it. Difference in the process.
So once the whole chief is done, then the person.
Yeah.
So only one individual is allowed to carry out the chief. After the whole chief is done, then the cross would be done by the opposing
So
party.
all 3 witness chief and
Then
then
the yes, ma'am.
Okay, no worries. Now I would like to call what? You take oath and whatever you will be stating this court today in front of the minister, that will be true, and you bind yourself to that.
Yes,
Please introduce yourself to the court.
I'm the Rajesh Kumar, watchman of the girls' hostel in SPVH1.
Okay. And can you explain the whole scenario? What did you see? What happened? Can you please be louder or take which language is comfortable? Okay, can you please be louder?
On 30th June, 7 p.m., Ada came to girls' hostel with the prior permission.
Point to be noted with the prior permission, so everyone was aware that she's going out.
Prior permission with the warden. I checked the permission and then she left with the scooter.
Left with the scooter. And did you find in what did you see in the CCTV footage? Can you please explain the full scenario?
I'm not the one who accessed the CCTV footage. of the date and the version of a girl source.
Okay.
Please, please.
And where
It is still not proved that our accused Farhan Mirza and also another accused has been involved in the crime. So on what basis? Only on a circumstantial basis, where they have not even their faces have not even seen in the CCTV footage, and also on this weak circumstantial link, how can they pray for death penalty for our accused? Our accused are innocent and.
Therefore, we pay to acquit all of them. Much obliged, Your Ladyship.
The question still remains the same, that why not application?
Session is over, how can you still make submissions?
sorry.
Very done, well done.
What happened?